Good morning. Can everybody hear me? This is Chris Lips from the General Counsel.
Yes, Chris, we can hear you.
So I'm trying to ask the parties, are there any preliminary matters that we should be aware of before we start the proceeding? Would you please indicate to the host so I can find that out? Thank you.
Yes, and we are live now, Chris. So we need to be on mute until we start, okay? But you'll be able to ask questions when it starts.
But I wanted to see if it was anything preliminary before we start.
Okay, all right. I'm just letting you know that we're live on YouTube right now. Okay. Okay. Joanne, can you put the slide back up, please? Good morning, Commissioner Beverly. Can you please say a few words so we can just test your audio real quick?
Can you hear me now?
Yes.
Hello?
Yes. Can you hear me, Commissioner?
I can.
Okay, you are a little low. Is it possible you can turn your volume up a little bit?
Hold on a minute. Let me, sometimes a foot or two makes a difference around here. How about now?
Just try to speak as closely to the mouthpiece as possible.
Okay. Can you, what if
Yeah,
I
that's
speak
much
louder?
better.
Is it better?
That's much better.
Okay. All right. I'll speak louder.
Okay, thank you. Thank you.
Okay.
Good morning, everyone.
Good morning.
Good morning.
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 Good morning, Sandra.
Good morning. Okay.
Okay. Good morning, everyone.
Back on mute.
Thank you. Good morning, everyone. I'm Brenda, and I'm the Commission Secretary, and we shall start momentarily. Thank you all.
Good morning, everybody. This is Chris Lipscomb, General Counsel. We're getting ready to start the public interest meeting. We had an open meeting just now. So the chairman and Commissioner Beverly will be coming in shortly.
This is Commissioner Beverly. I'm on.
Thank you, Commissioner. We can hear you.
Okay.
Good morning, everyone. I think I see everyone in their places and we are ready to begin. Commissioner Secretary Office, are we ready?
Yes, sir, we're ready.
All right. Good morning. We are going to call to order the public interest hearing of the Public Service Commission for formal case number 1162 in the matter of the application of Washington Gas Light Company for authority to increase existing rates and charges for gas service. I'm Willie L. Phillips, Chairman of the Public Service Commission. Also present
Is everybody else hearing that? I can't hear you.
is Seems we have a technical difficulty. Can you hear me? Everyone, please nod if you can hear me.
Yes, we can hear you, Chairman.
All right. I just heard the general counsel. He's apparently having technical difficulties. Can you hear me now, general counsel?
I'm gonna go ahead and come back in.
We can hear you. Okay, apologies, everyone. This is our new technical world, virtual world. So let's get this back on track. For the record, today is January 27th, 2021, and we are convening this virtual hearing at 11:13 a.m. This public interest hearing is being held to discuss the non-unanimous agreement of stipulation and full settlement filed on December 8, 2020, in formal case number 1162. WGL filed the settlement agreement on behalf of the settling parties, which are WGL, the Office of the People's Counsel, the Apartment and Office Building Association of Metropolitan Washington, District of Columbia Government, U.S. General Services Administration, and Baltimore, Washington Construction and Public Employees Labor's District Council. The two other parties in this proceeding, the Environmental Defense Fund and Sierra Club, did not join the settlement agreement, but stated that they do not oppose it. The settling parties represent that the settlement agreement includes a WGL revenue increase of $19.5 million over and above WGL's current revenues. The agreed upon increase in revenues includes a transfer of $99.5 million in plant in service from Project Pipes to rate base without attribution as to the merits of the prudence or reasonableness of the underlying projects. The Project Pipes surcharge in 2021 will be recalibrated for both the transfer of this $99.5 million to the base distribution rates, as well as the allowed spending amount noted in the order number 20671, the Commission's recent order on Project Pipes 2, in formal case number 1154. The settling parties agreed that the $19.5 million revenue increase will be collected through a 15% increase in the customer charge for all residential classes, with the remainder collected through the distribution charge. For non-residential rate classes, the revenue increase will be distributed on an equal percentage basis to all charges. For residential heating and cooling customers that use a monthly average of 59 therms, the distribution charges on the monthly bill would increase by $7.05. WGL agrees to increase the residential essential service credit from its proposed 90% level to a level of 100% of the distribution portion of eligible customer bills. WGL also agrees to withdraw its request for the revenue normalization adjustment and will not file another base rate case proceeding that will have a related customer rate increase until August 31st, 2021. WGL agrees to file an annual report with the Commission that reports the greenhouse gas emissions associated with the company's delivery of gas to district customers in the previous calendar year. Pursuant to Section 130.11 of the Commission's rules, the Commission must determine that the settlement agreement is in the public interest. Section 130.10 requires all settlement agreements to be in writing, contain all of the terms and conditions agreed upon by the signatories, be clearly and accurately labeled as unanimous or non-unanimous, be clearly and accurately labeled as partial or full, state whether the non-signatory parties oppose the settlement, indicate whether the provisions are severable, and stipulate the admission into evidence, the testimony, and exhibits filed in this proceeding. Generally, in reviewing a settlement, the Commission has used the same approach adopted by federal courts. Federal courts have recognized that a settlement should be approved if it is fair, adequate, reasonable, and free of fraud or collusion. Courts have noted that settlements conserve judicial resources by avoiding the expense of a complicated and protracted litigation process and are highly favored by the law. In evaluating settlements, courts are mindful of the fact that compromise is the essence of settlement and are hesitant to substitute their judgment for that of the parties. Additionally, approval of a settlement is appropriate if the Commission is satisfied that it was reached pursuant to an arm's length negotiation between the parties and is otherwise consistent with the law. We further note that the parties represent that the settlement agreement addresses and meets the standards set forth in DC Code section 34808.02, which requires the Commission to consider the public safety, the economy of the district, the conservation of natural resources, and the preservation of environmental quality, including the effects of global climate change and the district's public climate commitments. This public interest hearing is being held to answer questions, if any, posed by the Commissioner regarding the settlement agreement. At this time, I would like for the parties to identify themselves, beginning with the company, WGL.
Thank you. Good morning. This is Kathy Thurston Signius, representing Washington Gas Light Company.
Good morning. Next, we'll have the Office of People's Counsel.
Good morning. This is Tim Oberleiten, Assistant People's Counsel for Office of People's Counsel.
Good morning. AOBA.
Good morning, Your Honors. Exeter K. Caldwell on behalf of AOBA.
Good to see you, Mr. Caldwell. BWLDC.
Brian Petruska for Baltimore, Washington Construction Public Employers Labor Sister Council. Thank you.
DCG.
Good morning, Chairman Phillips. Brian Caldwell, Assistant Attorney General on behalf of the DC government.
EDF.
Good morning. This is Erin Murphy for Environmental Defense Fund.
GSA. If you're speaking, I don't hear you. Do we have a representative from GSA? All right. Moving on. Sierra Club.
Good morning. Susan Miller on behalf of Sierra Club.
Good morning. All right. Do the settling parties have any opening statements?
Your Honor, Washington Gas doesn't have an opening statement other than to say that the company believes that the settlement agreement filed in this case represents a fair and reasonable compromise of the diverse interests represented by the parties in this case. And we're presenting testimony today in support of the settlement, which will go into further detail as to why the settlement agreement is in the public interest. Thank you.
Thank you. Thank you. Office of People's Counsel, do you have open statements?
Thank you, Chairman Phillips. We do not have an opening statement, but we do have a statement to be read into the record as the proceeding moves forward. Thank you.
Thank you. AOBA?
Yes, Your Honor, briefly, like the other parties, AOBA does not have an opening statement, but I would like to note for the record that AOBA considers the settlement agreement in the public interest. Specifically, the settlement agreement reflects a reasonable compromise of divergent positions, reflects a much smaller increase than originally requested by Washington Gas, reflects a withdrawal of the interruptible tariff, as well as a withdrawal of the revenue normalization adjustment. The settlement agreement also reaches an agreement on the project pipes surcharge and also adopts a rate moratorium. And for these reasons, AOBA has concluded that the settlement is in the public interest. Thank you.
Thank you. BWLDC. I'm sorry, AOBA first. AOBA just went. Everybody, I have to apologize. I'm a little under the weather today, so bear with me. Have some patience. All right, BWLDC.
BWLDC supports the settlement, and we defer to Washington Gas Company, Gaslight Company's testimony as encompassing our position.
Thank you. DCG.
Thank you, Your Honor. The district government supports the settlement for the reasons, I'm sorry, I'm having some difficulty here.
We can hear you.
For the reasons outlined by counsel for AOBA. In addition, the district government would like to highlight one term of the settlement, which was intended to address some of the economic hardship that ratepayers are currently experiencing as a result of the COVID-19 pandemic, and that the provision that allows for low-income customers receive a credit on their distribution bill during the so-called heating months from November through April, equal to 100% of distribution charge.
Thank you for that. GSA? GSA's name. Okay, so do the non-settling parties have any opening statements? EDF or Sierra Club?
Thank you, Chairman. This is Erin Murphy for EDF. We do not have an opening statement. We would like to read a comment into the record subsequently in the proceeding on the settlement.
Thank you. Anyone else?
Mr. Chairman, this is Susan Miller on behalf of Sierra Club. We also do not have an opening statement.
Excellent. Moving right along. And just for the record, the commission does not object to not having opening statements. So with that, we'll now ask the company to please call its first witness.
Your Honor, we'd like to present a witness panel. We have one witness that is providing oral testimony and two other witnesses that are available if the commission has any detailed questions on the settlement agreement.
That's fine. Please proceed.
Thank you. Should we have all of them sworn in at this time?
Yes.
Thank
Commission
you.
Secretary Office?
Yes, sir. Can the
Please
three
swear.
witnesses, thank you. Can the three witnesses please raise your right hand? Do you each swear and confirm that the testimony that you're about to give in this proceeding is the truth and nothing but the truth? Thank you.
I do.
Thank you all.
Thank you.
All right.
All right, Mr. Tornimi, would you please state your name and title for the record?
Yes, my name is Robert E. Turnimi. I'm the Chief Regulatory Accountant for Washington Gas Light Company.
And are you familiar with the non-unanimous agreement of stipulation and full settlement that was filed in this case on December 8th, 2020?
I am.
Were you involved in the development and or negotiation of this settlement agreement?
I was.
Thank you. Mr. Lawson, would you please
Yes.
state your name and title for the record?
Sure, it's Andrew Lawson, and I'm a Regulatory Affairs Manager at Washington Gas.
And are you familiar with the non-unanimous agreement of stipulation and full settlement filed in this case on December 8th, 2020?
I am.
And were you involved in the development and or negotiation of this settlement agreement?
I was.
Thank you. Mr. Wagner, would you please state your name and title for the record?
James B. Wagner, Assistant Vice President, Rates and Regulatory Affairs,
And by whom are you employed?
Washington Gas Light Company.
And are you familiar with the non-unanimous agreement of stipulation and full settlement filed in this case on December 8th, 2020?
Yes, I am.
Were you involved in the development and or negotiation of this settlement agreement?
Yes, I was.
Will you please provide your testimony in support of the settlement agreement?
Yes, thank you, Counselor. Good morning, all, and good morning, Chairman Phillips and Commissioner Beverly. I am Jim Wagner, Assistant Vice President, Rates and Regulatory Affairs at Washington Gas Light Company. I'm providing oral testimony in support of the non-unanimous agreement of stipulation and full settlement reached by the company, the Office of People's Counsel for the District of Columbia, the Apartment and Office Building Association of Metropolitan Washington, the District of Columbia Government, Baltimore, Washington Construction and Public Employees Laborers District Council, and the U.S. General Services Administration. I am providing information related to the rates which produce the stipulated revenue increase. The remaining parties to the case, Sierra Club and Environmental Defense Fund, do not oppose the settlement described in the stipulation and in my oral testimony today. The stipulation is signed by the company OPC, AOBA, DCG, BWLDC, and GSA. The stipulation is a result of discussions among all parties and results in a fair balance across the various interests and requirements identified by each of the parties to the stipulation. Prior to the execution of the stipulation, the parties conducted extensive discovery during the proceedings, which included approximately 2,500 data requests, including subparts. Parties presented their positions in written direct testimony, supplemental direct testimony, and rebuttal testimonies, which also included exhibits. The stipulation is a comprehensive resolution of all disputed issues. The signatories of the stipulation represent divergent parties representing the interest of all customer groups, and the settlement is in the public interest. In addition to other benefits outlined below, settlement at this stage of the proceeding eliminated the need for extended hearings and post-hearing briefing, and conserve the time and resources of the Commission and all the other parties. The stipulated increase is a direct result of settlement discussions among parties and provides a satisfactory resolution of issues identified by parties in the case. The stipulation provides the company with an opportunity to earn a reasonable rate of return on its investment through a $19.5 million increase in the combination of customer charges, distribution charges, and peak usage charges effective for service rendered on and after the date of the Commission's final order in this matter. The company believes that the $19.5 million increase in non-gas revenues, which includes a transfer of $8.3 million currently being collected through the project pipe surcharge, thereby resulting in a net change in revenues of $11.2 million. So Chairman Phillips previously had mentioned the $99.5 million transfer of plant. The $8.3 million that I just identified is the revenue requirement impact of that is part of the $19.5 million increase. This is a reasonable resolution of the extensive revenue requirement testimony and information submitted in this proceeding. The agreed upon revenue requirement represents a negotiated resolution among parties with opposing interests, representing a broad array of customer groups that are directly affected by the outcome of the case. While it is true that there's no discernible trail that precisely details the derivation of the revenue increase, this is not at all unusual in regulatory settlements. The parties, including Washington Gas, have a wealth of experience from past Commission cases, including the precedent of a recent Commission decision in March of 2017 in formal case number 1137 to use as a benchmark to gauge the relative strengths and weaknesses of the various presentations. In the company's opinion, this increase is justified by the record evidence and will further the safe, adequate, and reliable provision of natural gas service by Washington Gas to its customers. The overall revenue increase of $19.5 million is applied to firm and interruptible customers' rates through an allocation that Washington Gas believes continues a movement to parity of return and collection of fixed charges. Through the allocation process, classes earning below the system average rate of return will receive a larger share of the increase, and classes earning above the system average rate of return will receive a smaller share of the increase. The calculated increase to each class is then collected by increasing the customer charges for all residential classes by 15% and for all non-residential customer classes between 14 and 19%, with the remainder collected through the distribution charges and the peak usage charges. However, it should be noted that these distribution charge increases will have a minor impact on low-income ratepayers participating in the company's Residential Essential Service Utility Discount Program, as the settlement would increase the credits these customers receive during the winter heating season on their bills to cover 100% of all distribution charges. The return on investment of 7.05%, including a return on equity of 9.25%, indicated in the stipulation, will be used to calculate a pre-tax rate of return to be used in the Project Pipes 2 surcharge, as well as in determining carrying costs applicable to storage gas inventory. It is not indicative of the acceptance by any party of the appropriate cost of capital and was not utilized to determine the level of the revenue increase in rates agreed upon by the parties in the proceeding. The stipulation includes a stay-out provision that restricts the company from filing a rate case or multi-year rate plan prior to August 31st, 2021. Attachments were included with the stipulation. Attachment 1 to the stipulation sets forth the actual rates to be billed customers per the stipulation, as well as verification of the agreed upon revenue increase. Attachment 2 to the stipulation provides a calculation of the amount of Project Pipes plant being transferred to rate base. And attachment 3 to the stipulation shows a calculation of the cost of capital agreed to in the stipulation. For all of the reasons I have discussed in this testimony, we believe the stipulation is in the public interest and should be approved by the commission. That concludes my oral testimony today. Thank you.
Thank you, Mr. Wagner. Is there anything else from the company?
No, Your Honor.
So I just have one question. Before I proceed, Commissioner Beverly is on the line. Do you have any questions for the panel? No, he's here. I don't think he has any questions. Commissioner Beverly?
I do not have any questions.
Thank you, sir. So, as I mentioned in my opening remarks, the company and the parties, settling parties mentioned, I believe in section 8, a climate impact section. And we're all well aware that pursuant to the Clean Energy DC Omnibus Amendment Act of 2018, the commission is required to consider the impacts on global climate change and the district public climate commitments in any major decision that we make. And that would include this decision. So we're grateful that the parties did address this issue in the filing. My question for the company is this: given that we haven't had many opportunities to make this consideration in the setting of a settlement, how would you propose that the commission review this section as well as the requirement that we have in this settlement proceeding?
Thank you, Chairman Phillips. I'll address your question. In Section 8, as you referenced, the company and the parties have included as part of the stipulation that we will file an annual report that reports greenhouse gas emissions associated with WG's delivery of gas to DC customers. As part of that report and per the stipulation, parties will get together within 60 days after commission approval of the settlement to discuss how that will occur I have had internal discussions with our climate folks, and we've begun looking at both the timing, structure, and agenda of that meeting, and also we will begin discussing the initial proposal that will be worked on with other parties in working towards meeting DC's climate goals.
Thank you for that explanation. I don't think I have to reiterate, although I will, to everyone listening, how seriously the Public Service Commission takes this authority. We take the mandate that the council has given us. I think it is a unique thing to amend the statutory authority for a body like the Public Service Commission. And we will do everything we can to ensure that we carry out this very important requirement. So with that is the only question that I had today. Before we wrap up, are there any other comments or any other matters that the commission should take under advisement? Hearing none. I will say that written comments or statements can be filed until the close of the record on February 8th, 2021 by sending them to Brenda Westbrook Sedgwick, Commission Secretary of the Public Service Commission. Our address is 1325 G Street Northwest, Suite 800, Washington, D.C. 20005. Or you can email at psc-commissionsecretary@dc.gov. I also encourage the parties, several parties mentioned that they had statements they wanted to include in the record. Please also submit those before the close of the record. There being nothing further, I want to thank all the parties for their efforts to reach a settlement in this important matter. I believe that it is a very good thing that we have settlement agreements.
Mr. Chairman, this is Chris Lips with the General Counsel. I think some other parties want to make a little statement. I think we need to ensure that they get an opportunity. I see people raising their hand. I'm not sure if you saw that.
I did not see that. I'd asked the parties to include their statements in written form, but if they would like to make a statement at this time, I will allow it.
Yes, thank you, Chairman Phillips. Yes, we would like, OPC would like to read a statement into the record before you close. Thank you, Chairman Phillips and Commissioner Beverly. I'm Timothy Oberlight, an Assistant People's Counsel, speaking on behalf of People's Counsel Sandra Matabu-Fry, in support of the joint settlement agreement reached in this case in the matter of the application of Washington Gas Light Company for authority to increase existing rates and charges for gas service. This case involves Washington Gas request for an increase of $35.2 million in additional revenues and addresses important policy issues that impact district ratepayers. After nearly a year of active and contentious litigation, the settling parties have reached an accord and submit the instant agreement for commission approval. OPC would like to note that it advocates to ensure that district ratepayers receive safe and reliable natural gas, as well as quantifiable and tangible benefits from their utilities in a manner that furthers the district's ambitious climate goals. Importantly, the settlement includes, and we wanted to highlight, a zero increase in Washington Gas's return on equity above its previous return on equity, results in a nearly 45% reduction in Washington Gas's proposed rate increase, and provides a much needed increase to the residential essential service credit distribution rate credit from 55% to 100%, as previously noted by Chairman Phillips and Counsel for DCG. This will result in lower bills for the most financially vulnerable customers during these tough times. The settlement also advances the district climate goals, as was noted previously. It will require Washington Gas to file a comprehensive annual report with the Commission regarding the company's greenhouse gas emissions associated with its delivery of gas to the district's customers. This report will allow the Commission and other stakeholders to track GHG emissions over time and inform future policy decisions. OPC looks forward to discussing the specific parameters of this report with the other parties as we move forward and is outlined by WGL's witness, Jim Wagner. This settlement also will insulate ratepayers from rate increases by requiring Washington Gas to wait until August 31st, 2021 to file any application for new rates, as was noted earlier. This would thereby extend the time frame by which the next rate increase could go into effect to sometime in 2022, providing further relief for ratepayers. As has been noted in various forms during this hearing, settlements always involve give and take by all parties. OPC does not enter into settlement agreements unless the end result provides benefits that could not be achieved through further litigation. OPC submits that this settlement provides an equitable resolution of the issues, represents a reasonable compromise amongst the parties, and benefits consumers, and is in the public interest. OPC will continue, as it always does, to zealously fight for district consumers. Thank you.
We thank the Office of People's Counsel. Would anyone else like to make a brief statement before we close?
Yes, Chairman, this is Erin Murphy for EDF. I'd like to share a brief statement on the settlement. Good morning. It is still the morning. As I said, my name is Erin Murphy. I represent the Environmental Defense Fund. Thank you to the Commission and Commission staff for the opportunity to comment today on the settlement agreement reached by several parties in formal case 1162, Washington Gas's rate case. EDF is an environmental nonprofit organization with 8,000 members and activists residing in the District of Columbia. Guided by science and economics, we seek practical and lasting solutions to resolve environmental problems. We are a party to this proceeding, and we neither support nor oppose the settlement agreement. Today, I'd like to comment briefly on two topics which are discussed in our filed testimony in this proceeding. First, the need for managed long-term planning by Washington Gas to align its operations with DC climate goals. And second, the opportunity to achieve measurable reductions in greenhouse gas emissions through the use of advanced leak detection. These topics are not addressed directly in the settlement agreement. First, there are deficiencies in Washington Gas's existing gas supply forecasts and planning process that need to be addressed to ensure the company aligns its operations and investments with the district's ambitious climate goals. In this rate case, the company continues to anticipate increases in gas sales, transportation, and total system send-out in the coming years, and the company appears to be planning its capital investments under a business-as-usual scenario. The settlement agreement does not address these concerns, and these planning deficiencies are not resolved by the company's climate business plan. However, the Commission recently opened formal case 1167 as a proceeding to develop a plan for DC gas and electric utilities that furthers the purposes of the Clean Energy DC Act and aligns with the district government's climate goals and plans. EDF anticipates that in formal case 1167, the Commission will develop a process to oversee the prudent management of the decarbonization and contraction of the natural gas distribution system while ensuring continued safe and reliable service. Second, as stated in our filed testimony, EDF believes that Washington Gas should use advanced leak detection, or ALD, to identify and remediate super-emitting leaks on its system to reduce harmful methane emissions. EDF acknowledges and appreciates that Washington Gas proposed and this Commission approved an ALD pilot program in Project Pipes 2 to improve prioritization of leak-prone pipe replacement. But beyond pipe replacement, leak repair programs offer a faster and quantifiable pathway to reduce methane emissions in the district. By using ALD, Washington Gas could report on the leak flow rate of identified leaks and thus report on the reduced methane emissions achieved through leak repair. EDF appreciates that the Commission has ordered that the company's ALD pilot costs be recovered through base rates, and we hope that the Commission continues to consider the benefits of requiring a super-emitter leak repair program using ALD. Specifically, the Commission could order that WGL's ALD pilot program include a super-emitter program to reduce methane emissions by finding and repairing large leaks. EDF looks forward to continuing to engage with the company, the Commission, and stakeholders to develop a pathway to align the gas business with the district's climate goals. Thank you again for the opportunity to comment today.
Thank you, Council. Any other statements, comments? Last opportunity. Okay, wonderful. Before we conclude, I would like to just give my colleague, Commissioner Beverly, an opportunity to have the final word. Would you like to make a comment, Commissioner Beverly?
Good morning. I just want to thank everyone for their hard work in reaching this settlement, which avoids future unnecessary litigation. I do take these settlements seriously, and I don't want to undermine them by trying to second guess anyone, just trying to give you that assurance. I think you should have a free hand in doing the things that you think are appropriate. So with that, again, I thank everyone for their hard work, and that's it. Have a nice day from my perspective.
All right, I agree. There being nothing further for the commission, this hearing is concluded. Thank you.
Thank you, everyone, and have a good afternoon.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you.